Good evening, everyone, and welcome to tonight's TFA webinar. This is the first of a special two-part mini-series where we're going to be delving into the realm of farm rent reviews. So with farming profitability under pressure, particularly for the arable and dairy sectors, we have many TFA members who are considering whether it's appropriate to look at arguing for a reduction in their rent. So this mini-series of two webinars is going to provide some insight for members and others about how rents are reviewed and what might happen if the negotiations have to be settled by an arbitration. So tonight in part one, we're going to be looking at preparing for a rent review and responding to the landlord's proposals before thinking about the arbitration process if needed. Part two, which will take place on Wednesday, the 4th of March, we will focus on preparing for a rent review arbitration following the breakdown of negotiations between the landlord and the tenant. And I'm going to be discussing that whole area with two expert panelists who I will introduce to you just in a moment. But before we get going, just like to say a huge thank you to our sponsor, Roythorns Solicitors. They are supporting our TFA virtual events and knowledge share videos right the way through to March 2027. So we're delighted with that. For those of you who might not know Roythorns, it is a national law firm steeped in agriculture with 90 years of experience advising landowners and tenant farmers. And their lawyers are very active in various policy forums. And they say that they certainly get the bigger picture. So whether it's about succession or a new farm business tenancy or a dispute with your landlord, a share farming agreement, or even a collaborative natural capital agreement, Roythorns is there for you to advise and assist. Now, if you miss any of tonight's webinar or you want to rewatch it at a later time, we are going to record it. And once it's edited, it will be available on our YouTube channel. And you can find our YouTube channel by searching at Tenant Farmers. That video library has all of our past events, knowledge share, teaching videos and webinars and key news snippets. So we would certainly encourage you to pay a visit to that site and to subscribe to the channel so you don't miss any new content once it is uploaded. So let's get into tonight's topic. We're going to be using a constructed example, which I'm going to run through just now. We're going to put that example as a link in the chat so that you can pull it up to read it as we discuss it tonight. But I'm just going to give you a little bit of a view as to what that example is and what we'll be asking the panelists to answer questions on. So this is a made-up example, and I should say that any similarity to holdings or people, past or present, is not intended. So the farm is called Hawthorne Bridge Farm. It's a 350-acre mixed holding. It's in the West Midlands, rented under a full Agricultural Holdings Act tenancy agreement. It was originally granted in 1978, and the tenant is Mr. Jonathan Price, who is 68, and he farms in partnership with his daughter Emily, who's 34. And she lives with her own young family in a self-contained annex invested in by the tenant, but attached to the farmhouse. There are succession rights, but they haven't been triggered. No succession application has been made. The holding comprises of 235 acres of arable in a winter wheat, barley, oilseed, rape, grass rotation. It's got 100 acres of permanent pasture on which the tenant is running a sheep flock, 15 acres of woodland and rough ground, a 5-bedroom farmhouse, and that's divided into the main dwelling occupied by Mr. Price and the annex, which is occupied by Emily, her partner and children. They are the tenant's family, but it's not sublet. Emily works on the holding at weekends, mornings and evenings between her part-time job off the farm, and she also is responsible for the liveries around her part-time job. There is a traditional courtyard of stone barns, which are landlords' buildings, and modern livestock, implement shed and grain store, which are tenants' improvements. There's 2 cottages, one let on a short-hold tenancy with unconditional consent from the landlord, and the other used rent-free by a retired shepherd who had previously worked on the farm, and the tenancy allows for that as well. The farm supports a small livery business. It's got 6 DIY and 4 full liveries with unconditional written consent from the landlord. And there's contracting activity, hedge cutting and drilling for local farms. The holding, as you might imagine, has a few issues. Severe game damage is an issue to the arable crops caused by the landlord's sporting rights, which are utilised by a third party. And the landlord makes it really difficult for the tenant to make annual game damage claims, and the tenant feels bullied into keeping quiet. The landlord won't engage in getting extensive and much needed repairs done to the farmhouse and traditional buildings for which they are liable. Other relevant factors are the tenant claims the sustainable farming incentive over 150 acres. There's a HLS scheme recently been extended for another year over 75 acres. The land's predominantly grade 3, some arable areas are grade 2. The current rent is £29,750 or £85 per acre per year, and it was last reviewed back in 2019. The landlord served the notice for review, and the landlord's agent has come to the tenant just a month before the rent review date, demanding an increase to £35,000 or £100 per acre, and stating if they don't agree to the increase, they will have to pay for the application to the RICS for the appointment of an arbitrator on the basis that they are not agreeing to the reasonable increase based on market evidence. The landlord's agent has provided no budgetary evidence, minimal information about the comparables upon which he's relying, and the landlord's agent has also told the tenant that other tenants on the estate have agreed to a proposed rent of £90 per acre, and that this evidence is more important than budgets. The landlord's agent also states that they have applied a higher figure for the rent for the farmhouse on the basis that the tenant's daughter and her partner are living there independently. So whilst they do help on the farm, they have careers away from the unit. Now, I know I've run through that really quickly, but you can read it again in the chat and remind yourself of what the example is that we're trying to be using tonight. So let me introduce you to our expert panelists with whom I will be discussing this scenario with tonight. So firstly, let me introduce you to Ellie Allwood. Ellie is a chartered surveyor and valuer and comes from a Nottinghamshire farming family. She was previously a partner in J.H. Walter, and having joined the firm in 1994, prior to the merger with Brown & Co. on the 1st of October 2021. She is now divisional partner in the Brown & Co. Lincoln Land Agency team. She's a TFA recommended professional, and she specialises in agricultural tenancy issues. She's also a rural arbitrator. So great to have you on board tonight, Ellie. And secondly, we've got Edward Briggs. Edward Briggs is also a chartered surveyor and valuer. Many years of professional experience, I think 37, he tells me. Before co-founding Briggs and Stone in 2018, he was managing partner of Bidwell's Rural Division, specialises in landlord-tenant matters and dispute resolution, and is an arbitrator and mediator. So welcome both. Thanks for joining us this evening. For those of you who have joined us on the webinar, I'm now going to be quizzing these experts on their thoughts on this review, this constructed example. But if you have any questions that you'd like to put to our experts tonight, please look for the Q&A box on your screen. It should be near the bottom. Don't use the chat, use the Q&A function. And I will try to do my best to look through those questions, and any which are relevant, I'll put to Ellie or Edward through the course of the next 50 minutes or so before we finish at 8 p.m. So enough from me. I'm going to begin to ask the panel some questions on this example. So Ellie, let me turn to you first, if I may. So in our scenario here, we have a landlord who has served the rent review notice, and clearly they've come very late in the day to the tenant. Is this something which you would normally find, and how could the tenant have taken more control earlier in the process?
Thank you, George. Yes, it is something which we do often find. I have to say, if you take a step back in time, anybody who was facing a rent review in the year of foot and mouth may have realised the significance of approaching a rent review early or closer to a date. It could have an impact. And I do remember back in the 90s, late 90s, even between Lady Day and 25th of March and 5th of April, we saw differences in prices, etc. So there can be practical reasons for leaving it as late as possible. Or it could just be that everybody's just very busy, just hasn't got on with it. It doesn't help the scenario, particularly where the landlord then takes the stance that's taken here of if you don't agree, you apply for an arbitrator, etc. But it's not unusual. The relevant date is the rent review date. So years ago, it was affected by the date of appointment of an arbitrator, but that's gone now. It is the actual rent review date. And you asked the question as to whether the tenant could take more control earlier in the process. There's always that question, isn't there? Has the landlord served a notice? Are they going to do anything about it? It's remarkable how many telephone calls and letters and emails are not sent immediately prior to a rent review date in the hope that you don't poke the landlord into doing something. But if you realise that the landlord is going to pursue it, then yes, you could take up the note, could activate the notice yourself. And even if you're not having conversations with the landlord or haven't heard from them, you can be preparing, and we'll perhaps come back to that, things that you can be preparing your own notes to be ready for that approach when it comes.
And Edward, do you find this regularly that people come late in the day?
Yes, quite often. Good evening, everyone. S- Quite often I get appointed as an arbitrator, and one of the complaints of the one party or the other before me, generally from the tenants' representative, is that they have had no proposals from the landlord until right before the rent review day, and therefore there has been no other alternative other than to appoint an arbitrator because we technically run out of time if they don't. The point, as Ellie mentioned, is that arguably the landlord will quite often say until they get closer to the rent review date, they don't quite know what the economics of the position are going to be. But a month, in my view, is far too late. And generally, sensible discussions should be held in May or June prior to give that time. And I know that comes up to a busy period, but there is no real excuse to delay it until that time. We can all tell where the winds are going, but it is a common problem. And I know in your commentary later, George, you refer to the code of practice, and I think one of the desired outcomes of that code of practice is to try and redress this problem, to get earlier engagement and try and get a more sensible solution without having to resort to an arbitrator appointment.
So just stepping back a bit from this particular example where we've seen the landlord has served the notice here, Edward, if this tenant came to you for advice in advance of an available rent review, would you be advising them to serve a notice on the landlord in the circumstances of this case? And if not this case, what type of case would you be looking at serving a notice?
It's an interesting one that if we go back to the assumption in this case is the notice was served 12 months prior. If we went back 12 months, I think the answer is I wouldn't be advising the tenant to serve a notice because we are in what I would say slightly uncharted territory in terms of where we're going with agricultural productivity and profitability, and there are few and far between evidence. There's few and far between evidence of settlements of reductions that would give you encouragement to say yes, definitely serve a notice. I suspect in this case at the moment, because everything that's going on this farm, I don't think it would be appropriate to do that at this stage. If it was a straightforward farm if it was just sheep and arable with no other additions there, I may take a different view. But we haven't got that. And again, if I was looking at this in 6 months' time, I may take a different view again. If given where we are, where we may go. And the moment, the difficulty with rent reviews is it is a movable feast and very much is dependent on on the economics of the holdings.
So just to be clear, if they came to you now in this scenario, if there was no rent review available, would you be
I
giving
don't
the same
think I
advice?
would. I don't think I would be advising them to serve a notice just at the moment.
Okay, Ellie?
I agree with Edward's assimilation of the situation. I think you would have to inevitably. There's always the cost and there's the risk of activating it rather than, shall we say, letting sleeping dogs lie. You may seek to say what else could you incorporate within a rent review if you did trigger it. And I was noting particularly that in your scenario, you have referred to the fact that there is landlord consent for subletting the cottages and for the livery business, etc. So if we're in a scenario where there wasn't consent for those two activities, you may say, well, what else can we gain from having a rent review? So even if the rent didn't go as you originally hoped it would, you may say, well, we'll settle the rent, but in return, I need to have that unconditional written consent. So this tenant's been very astute and made sure they've obtained that. Or too often you do see activities carrying on with no written consent or time limited. And when the landlord is seeking to increase a rent or even justify a rent standstill for the tenant seeking rent reduction, they may focus in where they can put pressure on a tenant. So I would always say if you're having any negotiation and you haven't got your written consents in line, do look for the opportunity to do so. And I know there is a potential successor here, and having written consents would help there. But that's another webinar, George, on succession.
And just Ellie, just teasing you a bit further on that question. If not this holding, if not at this time, what type of holding might you be saying to a tenant that they should be thinking about serving
Yes,
notice?
I mean, we're looking here. I know we're going to potentially, look at the comments on budgets and comparable evidence, and that's just what the landlord has come to the tenant here and said, "Oh, the tenants are agreeing on the estate," and you have to look at how comparable they are. But if you were looking at generally the tenancies where you would be looking potentially for rent reduction, it would be the standard house, some buildings, and no diversification, etc., no sublets, nothing else going on. Then we start to bring back into the scenario the budgets. For a long time, we haven't focused on budgets. We've simply looked at comparable evidence, and the movement generally has been upwards or at least stand still. Whereas we know the budgets will show quite a shocking story, and it's bringing the budgets back into the equation. And dare I say, I think as agents, you could even say we've got lazy and avoided doing budgets. But going forward, the budget is going to show a very different picture to potentially comparable evidence. Because
Yeah, well, we
there's
might,
always time lag on rent reviews anyway, so the comparable evidence, it's very difficult to find comparable evidence as at this time. It's always a time lag.
yeah, we might come back to the issue of budgets, but we have a bit of a pushback from one of our attendees tonight, Robin Waters. And maybe I'll start with Edward on this one. Robin says, having lost subsidy that equated to the rent, how is it possible that farms are profitable now at the level of rent agreed in subsidy times, Edward?
Well, the answer is they're not. But it is not just budgets that drive the rents. And if you want me to explain the detail, the mechanism of that, George, I can go through what Schedule 2 of the Act says in the formula as
Yeah,
I
well,
reported.
maybe it would be a good time to just give us a view as to what the factors are that need to be taken into consideration in a rent review, and whether those factors are more important than another.
Well, the factors that should be taken into account, as stated in Schedule 2 of the Act, are the character and situation of the holding, the terms of the tenancy, the productive capacity, the related earnings capacity, the current level of suitable comparables, and a wide-ranging heading saying all other relevant factors. And there is no guidance in the Act to say that one is more important than the other. They are all detailed as issues that one should consider when assessing the review. And of course, in times of great profitability, landlords agents are very keen to talk about budgets. But I suspect at the moment they're much keener to try and talk about comparables. And the problem we have at the moment is the comparable evidence doesn't necessarily show, particularly on AHA 86 Act tenancies, that rents are falling. Because, as I alluded to before, there's quite often a time lag between times where we start experience economic difficulties with farming and when rents start readjusting to take into account that situation. And that reflects the 12 months notice that you have to give to serve notice. And then it's that period of time, well, when was a comparable settled, and was it last year, was it this year, and how relevant is it? So to take the point back that the budgets may indicate pretty dreadful profitability in certain parts of the industry, and other parts it may not be so. But the comparable evidence still supports levels of rent where we are currently at the moment, but that may not last over the next 12 months. And that's the point of trying to say that. That's probably why I'm saying to you that if you had come to me and said, as a tenant, would you serve a notice, looking at all of the diversification factors and everything that's going on here, at the moment I wouldn't. But that's not to say I wouldn't do that in 12 months' time.
Okay, Ellie, Edward's given us the factors that need to be taken into consideration in terms of a rent review, and we've talked about budgets and also about comparable evidence here. Quite often we hear from our members that landlords, agents, and sometimes other professionals argue that comparables are the be-all and end-all. They are the primary evidence that you need to be looking at for a rent review. Is that right? Is that right? And also, can you just say a little bit about what is a comparable? We're dealing here with an AHA tenancy, an Agricultural Holdings Act tenancy. Quite often, we sometimes get farm business tenancy rents quoted at tenants in these circumstances. So, is the landlord right to say comparables are the be-all and end-all? And what is a comparable?
Yeah, I would just before I do that, just go back onto the budget, just to say what the Act doesn't say is that the tenant is entitled to a living wage from this holding. The tenant's return comes out of that profit pre-rent, and unfortunately, there is no minimum wage for a tenant farmer. So, which is a difficulty when you're looking at budgets. And the other practical issue is we do know that on budgets, we talk about tweaking the bottom right-hand corner by changing one small factor higher up in the budget. But coming back to your comment on comparables, and particularly relevant, Edward's comment on time lag, because of comparables, they've got to be subject to a 12 months notice beforehand and being settled. The beauty of having budgets against comparables, if you've got comparables which were settled 2, 3, 4, 5 years ago, what you can do is do a budget at that time with relevant information at that time, then rework the budget today and see how that comparable would have moved. Because one of the biggest arguments landlords make is it's not a relevant comparable in that it's not recent. But the problem is, it refers to current rents passing. Well, what is a current rent? Is a current rent not what somebody's actually paying? The fact the rent can be reviewed every 3 years, it could be argued, well, the tenant didn't seek to review that rent, so the tenant must be happy, but equally same for the landlord. And maybe, I'll come back to your question in a moment, one of the issues which may start to factor into people's assessment of comparables and how budgets can be used to analyse comparables is that if more notices are being served by tenants, it starts to get into the ether. At the moment, there's been little activity. And I was, my own experiences over the last couple of years, wherever there's been a review, the rents have increased. But that does not mean that every rent has been reduced, been reviewed. And at all. It's where they've been picked off for various reasons. But we can still say, even where there's been a rent increase, what were the prices? What was the BPS, etc. situation then? Going back to your comment, the ideal comparable is the arbitrated settlement, where it's arm's length, with the evidence put forward by the parties, etc. True with comparable evidence, there can be a lot of reasons why people settled at that rent, and that can be the greatest strength for tenants, if particularly tenants on the same estate or close by, is if you understand why that comparable rent that was quoted to you has been settled. That can be quite helpful. That may be something that the agents can glean from another agent. Was it in hope that on the back of a succession, obtaining other land, etc. The problem with budgets is that tweak, that it takes very little to have significant impact on the bottom right hand corner, and we're all aware of that. So you can pick. It can be very easy to create a distorted picture or get two extremes. Whereas comparable evidence are supposed to be the freely settled rents between the willing and prudent landlord and willing and prudent tenant. But I do think budgets can be used, particularly where no two farms are the same. So you've got comparables which may be settled on a similar farm 2 or 3 years ago. And one of the things I do is try and apply a budget at that scenario to that farm then adjust it, yes, for acreages, different field sizes, yield capacity, tenancy terms, etc. And you move it forward to bring it forward because there are no two directly comparable holdings. You point about FBTs, one of the, shall we say, the worst enemies on the FBTs is we do have, the tenant farmers themselves may rent from the same landlord on the FBT and saying, why, how do I justify rent on my AHA being different to the rent on the FBT the other side of the hedge? There was lots of, you will start from the basis it's a different act. We know that in this day and age, we are starting to see some FBT tenants serve notice on their FBTs to walk away. You can't do that on your AHA unless you're prepared to lose perhaps your house, your building, potentially your core of your business. So you haven't got that flexibility there. So it's a different scenario. That flexibility adds value. The ability to add bare land onto a main holding adds another premium on top. The fact that everything comes with it. You may have a house which you have to live in. So there's lots of different scenarios which you can use to say that FBT rent is not comparable. If, however, it's the only rent that's available, sometimes we use those to compare different FBTs. An FBT next door compared to an FBT down 10 miles down the road, and there's a 20% difference in rent. Well, maybe that reflects on the value of the land then, doesn't it? So you can still use it, but it's how you use it. It's not a direct, you pay £150 there, you need to pay £150 here. That's
okay. So hopefully that answers the question that's been posed by Michael Summers as well, when he said, can you confirm that comparables have to be 86 Act reviews? So intrinsically, yes, but obviously there may be some relevance to an FBT rent for other
I used one some years ago. I was doing a rent arbitration, and I wanted to argue that the landlord had I got one or two really poor comparables, and one was bare land, and I wanted to show how this had a premium, but I didn't have a lot of other AHA bare land, but I had, I think, 4 or 5 FBT bare land, so I used them to compare FBTs with bare land against FBTs with houses. So it had its value, but I wasn't doing a direct, it's 150 there, so it's 150 on the AHA.
I think it's worth also noting, George, that the subject holding is also a very good comparable because it reflects exactly the holding that you're reviewing, and the analysis of a previous rent review or previous rent reviews can be a very useful mechanism, particularly as Ellie mentioned that the budgets have changed. And it's a comparable. The only difference is it's a different date. But if you analyse and adjust for that, then that comparable could be very suitable.
Yeah, and just picking on, sorry, George, we'll let you get a word in edgeways in a minute. But the other thing is that if you've gone through the pain of a detailed rent review, you've probably analysed the land, and some fields you could equivalent your top grade land and some of you really poor, and land doesn't change. You may field amalgamate, you may drain, but if you've got 4.5 ton yielding field, the chances are, is that 10 years ago it's 4.5 tons, it's probably 4.5 ton, or as crops evolve. Same now, the land probably hasn't changed. So going through that analysis, as Edward said on the previous rent review and budget, is equally applicable bringing it forward. Because we don't just have to blandly quote every acre the same. You can adjust it for yields and access and all sorts of things as well.
Okay, Edward, just getting into a bit of the detail here then, and one of the contentious issues that quite often arises in rent reviews is the value of farmhouses. And also in this case, we've got occupation of the annex by the daughter and her family. How do you, Edward, assess the value of the farmhouse in an AHA rent review, and how would you approach the issue of occupation of the annex in this case, where the daughter is clearly working on the holding, but also has an external job?
Thanks for that, George. The farmhouse is a very contentious issue. The formula in Schedule 2 doesn't provide for any differential other than you have to consider again those criteria that I set out, which include comparable evidence, but includes the productive capacity and the related earning capacity. You have to consider things such as the repairing liabilities, and everything that goes with the holding, i.e. all relevant factors. In my view, it's completely wrong to take an assured short hold tenancy rent, as many landlords try to do, and then try and discount it a bit because in their references, because it's an 86 Act tenancy. I think it is an unfortunate fact that many landlords agents now don't really understand the mechanisms of the rent review formula in the 1986 Act, because many of them haven't been trained with it and don't work with it very often. The holding, one should really just look at the holding as a whole, and one can try and analyze out the relevant parts of the holding, whether it's the land, whether it's the buildings, or whatever element. But the Act doesn't provide for that. We do it because we might be lazy and we're trying to prove a subjective point. But strictly speaking, we should be looking at the value of the farmhouse as part of the overall productive capacity and related earnings capacity of the holding. The person who lives in that house has generally, there's an occupancy condition that they must live in it under the terms of the tenancy, and generally there's a user clause that they must use the holding for agricultural purposes, and they must make a living out of that. And the rent of the house must relate to that. So you could do a comparable analysis, trying to find a comparable evidence of what something else made, and then try and break down how that was between the land, the buildings, and other factors. And then theoretically, what's left over, it could be the house, and then you look at that in percentage terms and then try and apply it to the same holding, to the holding that you're dealing with. But we do often go back to I suppose, try to put figures on the component parts, just almost as a check measurement, because clearly the house has a value. If you had no house on the holding, it wouldn't be worth the same as it would with a house. But it's trying to measure what that distance is, and given the obligations within the terms of the tenancy.
Thanks, Edward. So, Ellie, Edward's swerved the issue of the annex here in his answer to that question. Do you want to try and address the annex point?
I will.
How would you approach that annex?
I'm going to be cheeky and just go just a couple of comments just back on what Edward just said. I had a rent review where the comparable was a holding which had a house, but the tenant did not have to live in the house and was able to sublet it. And that's a counter argument is, yes, I agree in the main holding, having a house does add some value. And I entirely endorse everything Edward said about how you analyse that using comparables. The other side of it is where actually the tenant doesn't want to have to live in that house because they have their own house either owned or tenanted elsewhere. And we had the scenario where the landlord presented this as evidence and said, "Oh, but I've disregarded the sublet income." I said, "Yes, but it's more than a sublet income. What value do you put on the tenant not have to live in that house?" "Oh, no, there's no value attached to that." Until my client said, well, that's fine. I want to move out of my house. What are the terms? Suddenly, that became a very valuable consent. So, what's good for the goose is good for the gander. So that's the opposite side there. Look at what your comparables are. The annex, I find it's a difficult one because is it a scenario where you could sublet it to somebody else? Um, it's a self-contained annex, so they can have their own time. But would you have another tenant living there? I don't think you would. But then you've been able to utilise the tenant's main walls and structure to provide a house, albeit at your own cost. I think it's a classic one where there is shall we say, probably an acknowledgement or a rent that reflects the landlord's consent to alter the fixed equipment, because I suspect that tenancy will say, do not alter fixed equipment. Very rarely is that sort of that a landlord's actually use that, but I have at the moment got a landlord actually trying to put pressure on a tenant saying you should not alter fixed equipment. So I would suggest there would be some recognition, but without going down to precise figures, I would say it would be a gesture rent, but that might be not as much as a separate sublet property where you could sublet it to another tenant, but at least perhaps half or a third of that as some acknowledgement
I
there.
think I would have a different view to that,
Good,
Ed.
Go on, a bit of contention,
excellent.
Edward. Go on.
I think what you have to do here is that this is clearly a tenant's improvement or a fixture, and I'm not quite sure
Yes,
which
good
one
point.
it is. And therefore, I would go back to the the situation you had prior to the investment, which was, if I've read the analysis right, it was a 5-bedroom farmhouse. So I would be valuing it as a single 5-bedroom farmhouse as opposed to the what we probably have is a 2-bedroom annex and a 3-bedroom farmhouse. I would ignore the tenant's improvement, assuming that there's no landlord's contribution to it, and I would just approach it as a single 5-bedroom farmhouse.
Hmm.
Ellie disagrees.
No, I think it's a very valid point. But you then come to the point of how you treat improvements, which is a whole other debate as to how you do you black patch them, ignore them, or do you put them in, then value them
Indeed.
out, which
Yeah.
is like land agent's nightmare.
Okay, well, while we're thinking about the landlord's fixed equipment here, Ellie, how do you take into consideration the fact that there are huge issues of disrepair on this holding that the landlord is not addressing? Is that a factor in the rent review? And also the game damage issue, which the tenant is apparently being bullied into not making a claim for. Is that something that you could take into consideration in this rent review?
I can say thank you, George. The landlord's disrepair, yes, you can. You can't disregard tenant's dilapidation. So if the tenant's not looking after it, you can't reduce the value. But you can disregard the landlord's disrepair. Game damage again is a difficult one because obviously you've got the right on an AHA as opposed to an FBT. Under an AHA, you've got the right under Section 20 to claim for your game damage. Then there's always this argument about what actually is that game damage and what does it relate to and the costs, etc. I think that this would fall. I would definitely, as a party, approach this to say, even if the argument is to say, well, you are statutorily entitled to claim for lost crop under Section 20, you're clearly on a holding which is affected by a shoot, and there could be wider implications. And I think that goes into the you have to take into account the character of the holding, etc. So I think it's a wider issue than just, oh, you can claim your damage under Section 20 because there are costs associated with that. Then take into account the fact that the landlord makes it very difficult. I don't think the landlord's got much of a strong case to argue, well, disregard the game damage because you claim under Section 20, when clearly the evidence is he's being difficult. I assume he's using the classic, it's anything but game that's eating the crop. As
I
we've all
think
seen some wonderful ones.
George, if I can jump
Yes,
in,
I would.
we have to put ourselves in these shoes of the hypothetical parties and the prudent and willing tenant and the prudent and willing landlord, and it's how the prudent willing tenant would bid on the rent review date, take into account all the relevant factors, and being prudent and willing, they would be aware that there's a problem with the game damage, and they would be aware that the landlord hasn't honoured their repairs, and their bid for the tenancy or their bid for their rent would factor those in accordingly, and therefore they would pay less. They may be entitled to recover compensation under the Act, as Ellie said, but they might not want the hassle of that. And there's a reflection of that. And if the landlord has a history of not doing his repairs, the rent similarly will reflect that, because a prudent and willing a tenant will not wish to enter into a confrontation with his landlord to try and do things that he shouldn't really have to do.
On a practical note, George, right at the beginning, you asked, could the tenant do something about the rent review earlier, when I said about, they could be preparing for it. And I think that's an absolute classic, is if this argument's going to be raised about, well, gain damage has an impact on the rent, where's your evidence? Where's your, evidence of your photographs, evidence of making claims to the landlord, evidence of the landlord's refusal to pay? All that is a wonderful source of evidence to give to your agent, so that they have got some ammunition for going in. And you can be doing that. I always call it the homework list. There's lots of things you can be doing in the background to help your case.
Excellent. Thanks, Ellie. Ed, I know this is a topic that you've been dealing with in some specific cases where you've been acting for tenants here. What impact do the non-agricultural activities have on the rent, in this case here, the livery and the contracting, when they've been developed fully at the expense and expertise of the tenant without any input from the landlord? You might want to get into that dreadful phrase that we sometimes hear, latent value, when you give your answer to that question. And obviously, if you've got other examples of diversifications that you might want to bring into play in answering that question, that'd be helpful too. So how would you approach that?
Well, here we have a situation where there is, I think you used the phrase, unconditional written consent to do works, and therefore to do things such as the liveries and the cottage let. Now, therefore, I would consider such consents as being part of the terms of the tenancy, because in the case of the livery, as if I'm reading your analysis correctly, all of the work and the provisions of the stabling, etc., have all been provided by the tenant. The Act tells us, and the formula tells us, that we must ignore any tenants' improvements fixtures on the basis that the tenant shouldn't have to pay twice. It shouldn't have to pay rent plus rent for its own investment. It shouldn't. The tenant shouldn't have to pay for anything that it does to improve the rental value of or the productive capacity related earnings capacity. And there are many ways of looking at how that is done, but the appropriate way is to value as if those assets are not there. And so if you look at the livery example, which is the easiest one, you value bare land or whatever the stables may be standing, and you value grass where the horses might be grazing, but as grass, as if it were sheep grazing, or etc. But then you can have this wonderful phrase, latent value. And latent value is the best guide is that there was a case called Dunn versus Barclays Bank, I think quite a long time ago. But in effect, what that said is that if the tenant could invest relatively little money to make something far more valuable, then it is likely that that would be accounted for by the prudent and willing tenant, the hypothetical tenant. But that potential would have to reflect the cost of doing the development, maybe the requirement to gain planning permission, all of those things. But instead of grassland, say, being £50 an acre, it might be £60 an acre to reflect that potential, where the equestrian value might be £80 or £100 an acre. So it shows that there is a reflection, but a small reflection, that there's potential to do something, but you still have to come back that you ignore what the tenant has done, because that is the tenant's investment, and the tenant has consent to do it as part of the terms of the tenancy. With the cottages, it's more difficult because they are clearly the landlord's fixed equipment. It's going to be interesting, the reference to assured short-hold tenancies, because in a few months' time, we of course won't have those. We'll have these assured periodic tenancies, which have a different meaning entirely because they may go well beyond the term of the tenancy. But the usual approach there is to reflect if there's an unconditional consent to pay the landlord a percentage of the rent that is likely to be received. And again, you have to stand on the rent review date and look at what may be reasonably foreseeable at some point in the future. So you can take a view on where you think residential rents may go. And that's a very interesting question in itself following this new act that might be coming in, or is going to come in. And then you look at how much of that has been derived by the work that the tenant has done to the property. Has the tenant put boilers in, double glazing, all of those things, which is often the case because some of these estate properties are very poor generally in condition to satisfy EPCs. And the tenant's taking all the risk. They've got to collect the rent. They've got to pay an agent to do that. They have to take the voids, etc. So you then get a percentage that is generally significantly lower than the 50%, which most landlords agents will try and get to. With the service tenancy, that's slightly different because I'm assuming he has protection, and if he has, and he may have a fair rent, and therefore generally the obligations are slightly less onerous on the tenant to maintain. They still have to maintain, but the rental levels are lower as well, and we find that the percentages are slightly higher to reflect that. But it comes back to the point that without that tenant's investment, whether it's a fixture or an improvement, you have to ignore it, and you have to look at the asset that you have and say what would be that the rental value applicable to that unimproved asset, and then is there any latent value, any potential to improve it? But what would be the cost of it? Would there be planning permission required, and all of those things that go with it, and then value into risk.
And I would just on that issue about the tenant's investment, what if there is little tenant's investment in terms of the fixed equipment, but the success of the diversification is purely because of the expertise of the tenant and the business that the tenant has created and running from that facility? Would that be treated differently?
Was that to me, George?
No, Mr. Edward. We'll come back to you in a minute, Ellie. Don't worry.
The principle is the same. You have to clearly, if there's minimal investment required, I don't know, I'm just trying to think, for example, if the tenant was running a car boot sale, take for example, and there was unconditional consent to do that, then that's a landlord's field. But the tenants made the entrepreneurial decision to do it and run it, and it's, they're not for the faint-hearted, but they can be profitable. Then you come back to the analysis, well, it's let as a field, but was there latent value to run it as a car boot sale? But what would a tenant want out of that to make it worthwhile? What percentage of the profits? So the principle is the same, but it's a slightly different analysis because unless the tenants put in roadways and other things, still the field is the landlord's field.
Ellie, sorry, you wanted to come in and I shut you up.
No, not at all. No, I missed who you, with ease, which you were referring to. The other comment, of course, is it's the hypothetical tenant. And I think we always have this argument. I've had an argument with a landlord where, you should be running B&B. And I said, right, this very busy farmer, I don't want to be stereotypical, but you may be a gentleman who's a busy farmer. He's going to be cooking bacon and eggs, is he? And this, what would the hypothetical tenant do for that in that case? I think you mentioned obviously the cottages, but there's also the contracting. I'm just going to skip back quickly to comment on that. Because in the scenario you mentioned contracting activity, hedge cutting and drilling for local farms. I think on that basis, I would say, no, that's the entrepreneurial skill of the tenant, no additional value. Because those are a piece of equipment he would have anyway. He needs them for fulfilling his own tenancy obligations. If he was using his building and housing all sorts of machinery which went off skimming surfaces off roads and replaning roads, and it was a commercial enterprise, the latent value, even if you were doing it within the landlord's building, I think there could be some additional value, possibly the landlord could argue there, albeit fully taking what Edward I think would say is, but that's the tenant's own business, their own entrepreneurial skill. These are the grey areas you
I,
have these debates over.
I think in that scenario that the landlord's got some justification to say, well, you're running that business from my premises, and without that premises, you wouldn't be able to do it.
Yeah.
But then you have to look at, well, has the landlord tenant put in all the concrete and all of those sorts of things? But I tend to agree with you. If it's a small level hedge cutting, and I wouldn't apply any
Disregard
benefit to
completely.
that at all.
Yeah.
Okay, just for the benefit of Graham Oliver, who's reminding us that the cardboard sale scenario is a non-agricultural activity, that would be something that you would have to get the consent of the landlord for in that scenario that Edward was talking about there. Ellie, Edward talked previously about the agricultural landlord and tenant code of practice here. In this scenario that we've been talking about, what's your comment about the extent to which the landlord and the landlord's agent are complying with that code of practice?
I think the just generally in terms of landlord and tenant, the avoidance of carrying out repairs, etc. Now, the tenant commissioner cannot get involved in issues where there are dispute mechanisms, and there are dispute mechanisms and ways of dealing with this. And the tenant may want to talk to his agent about the ability to carry out repairs and recover the money from the rent, but clearly do that with advice because non-payment of rent is a serious issue. The and the game damage. I think they at that point, if I was a tenant's agent, I would be referring to the code of practice to say you're not acting in accordance. You have a statutory, there's a statutory right here. This is not subjective.
But the tenant's being bullied not to put a claim in, Ellie.
Yes, exactly, absolutely. Well, I would be hackles up at that point. Absolutely. I think just in terms of the rent review, the fact that they've come very late in the day, yes, you could say, is that good practice? Perhaps not. But have they done anything wrong? Well, it's part of the course. Where I do take exception, and Edward and I, we're both chartered surveyors, and one of the reasons being chartered surveyors, we are strictly controlled as how we act. And to go to a tenant who's not seemingly got his agent on board at that time and say, you settle at this, otherwise you will pay for an arbitrator, is misrepresenting the statutory procedure. And at that point, if I was then instructed, I would be, and the landlord's agent, I would be certainly referring to the code of practice, just so, because we all as professional bodies, be it RICS, Central Association of Agricultural Values, we've signed up to that. It's not statutory, it's not mandatory on us, but we've all given it more than lip service, and so I'd be wanting to refer to it, and we should not, as chartered surveyors, be misrepresenting the facts to a tenant. Now, you could say, well, you weren't there to hear it. Has the tenant misunderstood? And that's so often why I say to the clients, just get them to confirm it in writing, because then I've got them. Because people misunderstand. With a lot of things being talked about, with the rest of the world, you do misunderstand. But unfortunately, that scenario is not, I'm not surprised at it. I've heard it said. So I'm afraid I suspect that that's what was said to the tenant, and the landlord's agent was wrong to do that. And I'd certainly cite in the code.
Edward, would you agree, Edward?
Yeah, definitely. The code only came in a couple of years ago, and we didn't have that. We could refer matters to the RICS if we felt things were not being done, but that's quite a difficult bar to. And I have high hopes of the code and the new commissioner that's been appointed, and that's what he's there to try and do, and try and ensure that we have a much better communication between the parties.
Okay, we've got a few minutes left of our hour together. It's gone really quickly, and you've been really generous with your time. So here's the $64,000 question for both of you, starting with you, Edward. So taking all of the factors that we've discussed tonight and the scenario that we've been going through, what's your advice if you were advising the tenant here? Should they agree? Should they disagree? Or should they even argue for a reduction?
They shouldn't agree. They should disagree. I think I would probably say if he wants to pursue this as an increase, let's argue for a reduction. But if you can agree a standstill that's probably the best outcome for you.
Ellie?
I certainly would. I would perhaps, if I was having that within these four walls conversation with the tenant, say there could be grounds for that increase because it's got other things involved at that time. Going back to Edward's comment, we haven't got enough comparable evidence backing us at the moment to fight against the landlord saying, well, the budget's just a tweak on a spreadsheet. But I would exactly agree. If you stood on, well, obviously, if you were doing it by agreement, you'd need to change that rent by just £1 because an arbitrator can award exactly the same rent to the penny. But for parties to agree, you've got to vary it by £1 and £1 up and one down. I'd be generous and offer the landlord that extra £1, and then you're fixing it for 3 years. Otherwise, you're taking a view. You could see scenarios where you serve a notice for next year and say, well, can we delay it and see what happens? But I think the landlord might be thinking, crikey, what's coming down, the line with profitability, and say, yes, we'll settle at rent standstill.
Okay, so final thoughts on this one then. So assuming the tenant takes your advice and they don't agree, but the landlord is continuing to pursue the idea of an increase. So there's no agreement and the landlord wants to press matters further. What are the next steps in respect of arbitration here? Edward's already talked about that a little bit. But what are the next steps that we will set things up for our next chat next month?
Do you want me to answer that one, Ellie?
Ellie, you go first, then Edward, you can come in.
I'll be very quick. I would say I would make my offer in writing to the other side to make it quite clear as a Calder Bank offer. I would put that offer on the table to say we will settle today at this rent, and then the agent would explain being without prejudice saves costs. I would put that on the table anyway, even before the arbitrator's applied for. And I certainly wouldn't be contributing towards the application fee towards an arbitrator. Landlord, you want to pursue, you pay for that one.
Edward?
Yeah, I agree. I mean, you could just sit there and do nothing and see whether the landlord does apply for an arbitrator or serves another notice for next year. It will be the landlord's decision to make. That would be the way I would deal with it. And as I say, put a Calder Bank in, and which is without prejudice, save us to costs. And if the landlord doesn't beat that, then that would cause them a big cost problem. So that's how I would do it. And it would be interesting to see what the landlord decides to do.
Okay, well, we will have a look at that when we come back next month then, because I understand that the landlord does press matters to arbitration, and we'll discuss how that goes when we meet together next month. And just for the benefit of viewers, you're talking about a call to bank offer without prejudice, save us to costs. So it's an offer made between the parties, so the offer itself is not disclosable to the arbitrator until, if an arbitrator makes a decision, there's an award of costs, and the arbitrator can then see the offers that were made by the parties towards the end of those negotiations and decide where costs go. Well, I'm going to draw things to a conclusion tonight, and I really want to say a huge thank you to Ellie and Edward for your massive expertise tonight in answering those questions. It's been really interesting, really fascinating just to get into the details there. So thank you so much for your time this evening. And also thank you again to our event sponsors, Roythorns, solicitors, as I mentioned earlier. So as I said, next month we will be returning to this topic, but we will do so on the basis that there is no agreement between the landlord and the tenant. Matters do proceed to arbitration. So if you join us again on the 4th of March at 7 p.m., Ellie and Edward will be back with us again, and we'll be focusing on how we prepare for a rent review arbitration following the breakdown in negotiations, and how that will go forward. So do look out to register for that. More information is available on our website, www.tfa.org.uk. It's a free event, as tonight's was. So we really do hope that you found tonight's webinar interesting. I've been involved with the TFA for 30 years, and I'm still fascinated by the ins and outs of a rent review. scenario, and we've had two real experts tonight helping us with that. So it's been absolutely excellent. So thank you very much for joining us tonight. See you again on the 4th of March. Good night.